All right, let's jump right in. We usually think of law as this dusty, old set of rules that never changes. But what if a legal system was actually given a mission? Not just to keep things in order, but to actively rebuild a society and try to heal the wounds of a really unjust past. Well, that is the incredible story of modern South African law.
And this really gets to the heart of what we're talking about today. Can the very same legal tools that once upheld injustice be turned around and used to build a more fair, more democratic, and more equal future? I mean, it's a huge undertaking, right? And South Africa's journey gives us this fascinating, real-world look at how it's being tried.
So, what exactly is this mission? To get a handle on South African law today, we absolutely have to start with its core purpose, the engine that drives the whole thing. And that mission, it has a name: Transformative Constitutionalism. It's this powerful idea that the Constitution isn't just some document that sits on a shelf protecting the way things are. No, it's an engine for massive social change. It's basically a roadmap for actively taking apart the legacy of apartheid and building something totally new, using the law as the main tool for the job. And this quote from the legal scholar Karl Klaar just nails it. He called it a commitment to substantive equality. That doesn't just mean equality on paper. It means real, actual equality in people's day-to-day lives. It's a social and political project, not just some technical thing for lawyers to argue about.
Okay, so that all sounds pretty grand, right? But what does it actually look like in practice? Let's zoom in on one of the most difficult areas it had to tackle: property rights. I mean, this was at the very core of the old system's inequality. So, first things first, a couple of basic building blocks. In law, you've got a real right and a personal right. A real right is your right over a thing, like Sipho owning his car. He can defend his ownership against literally anyone. A personal right, on the other hand, is against a specific person. So if Zanelli leases that car from Sipho, her right is just against Sipho to make sure he provides the car. It's a personal agreement.
Now, here's where it gets really interesting: the difference between owning something and just possessing it. Ownership is the legal right. It's the strongest right you can have. Even if your car gets stolen, you are still the legal owner. Possession is just the physical reality of who has control of it. A thief, for example, is in possession of the car, but they are absolutely not the owner. So traditionally, an owner's power was almost a superpower. It was thanks to this incredibly strong legal tool called the res vindicatio. What it meant was that an owner could reclaim their property from anyone holding it, period. It didn't matter if the person living there was doing so in good faith, had nowhere else to go. None of that mattered. If you proved ownership, you got your property back. End of story. But here's where the transformation kicks into high gear. The new South African Constitution comes along and just flips the script. It doesn't get rid of ownership, but it completely changes the rules of the game. Section 25 protects property, sure, but it also says the state can carry out land reform. And then Section 26 drops a bombshell. It creates a new, powerful right to have access to adequate housing. These rights don't just exist next to ownership, they actively limit it. The owner's power is no longer absolute. So just look at what this means for evictions now. That old absolute power, it's gone. First, an owner has to go to court. Taking matters into your own hands is illegal. Then, the court's job isn't just to rubber stamp the owner's request. It has to ask, is this eviction just and equitable? It has to consider the people involved, especially the most vulnerable, kids, the elderly, households headed by women. And crucially, the court looks at whether these people have anywhere else to go. This is transformative constitutionalism in action, balancing an owner's rights with the basic human dignity of the people living on the property. Okay, so we've seen how the Constitution reshapes rights over physical things. But what about the promises we make to each other? Let's shift gears and look at the law of contracts. At its heart, a contract is pretty simple. It's just a legal bond, a promise the law will enforce. It creates a right for one person to claim something and a duty for the other person to deliver it. It's the engine that makes our whole economy run, from buying coffee to signing a mortgage. And for hundreds of years, the world of contracts has been ruled by one simple, powerful, ironclad principle. It's summed up in this Latin phrase, pacta sunt servanda. It means, simply, agreements must be kept. You signed it, you're bound by it. That's it. But you can probably see where this is going, right? In a country on a mission to promote fairness, this rigid a deal is a deal rule runs into a huge problem.
What happens when a perfectly legal agreement is also deeply unfair? This sets up a classic legal showdown, the sacredness of a contract versus the constitutional need for fairness. What's wild is that this idea of fairness in contracts isn't new at all. It's actually a comeback story. If you go way back to ancient Roman law, good faith, or bona fides, was a huge deal. Courts made sure deals were honest. But over the centuries, especially with English influence, that idea just faded away, replaced by this supreme value of freedom of contract. So now, we're in a total battleground, with those old rules clashing head-on with these new constitutional values. And for a long time, the courts really held the line on this. The textbook case is Brisley v. Drotsky, and the court said it plain as day. A judge can't just tear up a contract because they think it's unfair. A deal is a deal. Pacta sunt servanda is king. And this, right here, is the heart of the conflict. It's a clash of two totally different worldviews. On one side, you've got freedom of contract, which basically assumes you have two people with equal power freely making a deal. On the other side, you have Ubuntu, a core South African philosophy that's been recognized by the courts. It's the idea that I am because we are, and it demands that the law looks at the real human impact of its rules. And this just begs the question, doesn't it? Is it really a free choice when a giant corporation with an army of lawyers hands a standard, take-it-or-leave-it contract to an ordinary person who has no real power to negotiate? In those situations, freedom of contract can actually end up reinforcing inequality, not promoting real freedom. So if the courts are often hesitant to just step in and rewrite people's contracts, where does the transformation happen? Well, sometimes the answer doesn't come from a judge. It comes directly from Parliament. And here it is, the Consumer Protection Act, the CPA. You can think of this as Parliament stepping in and saying, okay, we are going to actively inject the values of fairness and dignity from the Constitution into every single transaction, every single day. The CPA is all about rebalancing the scales. It gives courts the explicit power to protect consumers from unfair or unjust terms. It says you have a right to get information in plain language. It gives you real remedies if you buy something that's defective, and it seriously clamps down on those old as-is clauses that sellers used to hide behind. It is Parliament directly addressing that power imbalance we were just talking about. Which brings us right back to where we started, but with a much sharper question. The old law was simple. Agreements must be kept, but the new constitutional reality in South Africa adds a crucial, unavoidable follow-up. But must they also be fair? The whole journey of South African law shows us that's not an easy question, but it's a question that the legal system now has to wrestle with every single day.